Let's do 1 second, Judge. Almost there.
This is cause number, let me see. Right. Cause number 2018L7246 in the interest of TLL and HML. We're by Zoom. We're starting out this afternoon. I see the attorneys and parties are present. Mr. Falco, who's your next witness?
Dr. Pujols.
Hey, Dr. Pujols, if I can get you to raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? And you'll need to unmute yourself, Doctor.
I do.
Okay. So, Mr. Falco, you may proceed.
Thank you, Your Honor. Doctor, I think you're muted. Would you state your name, please?
Jessica Pujols.
And are you, we've called you doctor, are you in fact a doctor?
Yes, doctorate of psychology.
All right. And where is your office located?
I work out of 2 different offices. The one for this case is based in Houston, Texas.
And what type of psychology type practice do you have?
I'm a licensed clinical psychologist with a specialty in forensics.
And I'm going to try to do a screen share here if I can. My technology sense works. Well, I may have to go off for a second. All right. There we go. Dr. Pujols, can you see the CV with your name on it that I'm sharing to the screen now?
Yes.
Okay, I'm going to scroll through this real quickly. Just make sure that you can see all of it. And I think that's it. Doctor, is that your current CV?
Yes.
And is that up to date as of today?
Yes.
All right. I'm going to offer as R1 the CV of
No
which I've given to the court, and I've also shared R1.
All right, so R1 is admitted.
Thank you. All right, and Doctor, have you been contacted by Farah Louvier to engage your professional services?
Yes.
And what did Ms. Louvier contact you about doing for her?
She requested a psychological evaluation for her pending custody case.
All right. And just, I know you've got a lot of things on your CV, but are you, in your forensic psychology practice, have you done psychological evaluations for purposes of custody cases?
Yes.
Have you, in fact, also done custody evaluations under the rules and guidelines of the state of Texas?
Yes.
Now, in this particular case, you were not engaged to do a custody evaluation, correct?
Correct.
Right. You're purely evaluating Ms. Louvier and her psychological mental status in relation to her custody case. Is that correct?
Correct.
All right. And as a part of your job and a part of your practice, have you done these type of evaluations on the appointment of courts?
Yes.
And I noticed in your CV, there are several courts listed that you've done those for. Is that correct?
Correct.
And so are you familiar with the guidelines of APA, as well as the state of Texas legal parameters for doing these types of evaluations?
Yes.
All right. So in the course of did you in fact conduct an evaluation of Ms. Louvier?
Yes.
And in the course of doing your evaluation, if you could just briefly tell the court what you looked at in order to conduct your evaluation. How does that happen?
Well, the evaluation typically consists, and for this case consisted of an interview, face-to-face interview. We did it virtually. An intake with those kinds of questions, her background information from her perspective on the case. I reviewed her medical psychiatric records, and we conducted some questionnaires and cognitive tests. So we did a battery of tests as well at the end.
Okay. And when you talk about the test, what psychological tests did you use in evaluating Ms. Louvier?
Yes. We did the St. Louis University mental status examination to screen for any cognitive impairment. I had her complete the MMPI, which is a comprehensive personality and psychopathology inventory. I gave her the substance abuse subtle screening inventory for those with history of substance use, a depression and an anxiety questionnaire, or separate questionnaires.
And are those the types of, I guess I'd refer to it as more objective questionnaires that are usually used in your practice to conduct evaluations of this kind?
Yes.
And you talked about the MMPI. Is the MMPI something that's usually used in conjunction with making diagnoses under the DSM as far as any types of?
Yes.
I know that's not the only kind of document.
I think Mr. Falco, I think we lost you for a little bit. If you want to restate your question.
Yes, I'm kind of losing people too. So is the MMPI something that you usually use in conjunction with the DSM to make diagnoses of disorders?
Yes, it's one of the top ones that we psychologists use, and I often use it.
I understand you also use some other tests, but that's sort of the one that's pretty much universally used. Is that correct? Especially
in courts, the court system, yes.
All right. So now getting back to it, you told the court what you looked at in terms of Ms. Louvier. Did you also conduct, once you had done that testing, did you conduct follow-up interviews with her?
We did speak briefly just on a few points, And then we talked about the results, the report itself, after the fact, after the testing period.
And I'm going to try sharing one more time on the screen here, if I can manage that. All right, and I'm going to show you what I have tendered to the court as Exhibit R2, which is entitled Confidential Psychological Evaluation Summary. And again, I'll scroll through here sort of quickly, but I know you have this, so just want to make sure we're both looking at the same thing and we're giving the court what you did. I'm at page 4. Is this your report that you prepared after evaluating Ms. Louviere?
Yes.
And is that basically a shorthand rendition of what your testimony will be today as far as your findings with regard to Ms. Louviere?
Yes.
Offer R2 at this time, Your Honor.
Any objection, R2?
No objection, Your Honor.
Okay, respondents 2 is admitted.
All right. Okay, so if I understand it correctly, this evaluation was being done with an eye toward whether Ms. Louviere could safely care for her 2 minor children. Is that a fair statement?
Yes.
And I know you can't evaluate every external factor, but from a psychological, emotional standpoint, is that what your task was in this case?
Yes, it was.
All right. And can you tell the court, just generally speaking, what you found with regard to Ms. Louviere?
Of course. So her active diagnoses, according to the DSM-5, she did meet criteria for adjustment disorder with anxiety and depression or depressed mood. Now, what that is an extended response to not necessarily a life-threatening trauma, but a very stressful situation. So having difficulty coping with, in her case, the process of the divorce and custody. She did exhibit symptoms of anxiety and depression and just difficulty managing her emotions as she was going through the court process. She did, in fact, receive mental health services, which she continues to do. So that's the number one recommendation I would have for someone with adjustment disorder. Historically, she did meet criteria for alcohol use disorder, but she is no longer having symptoms of that disorder. So I've marked her as in early remission, meaning she's had over 3 months of sobriety and alleviation from those symptoms. She also has a history of postpartum depression from her pregnancies that was resolved within 6 months to a year after the birth of each of her children.
And let me just kind of run through that with you. The adjustment disorder, does that type of a diagnosis in and of itself make someone unfit to parent their children?
I don't know if you can see me. Hang on one second.
I can't, but.
There we go.
Okay.
It clicked
Okay,
off. There we go. Could you repeat the question?
Yes. You said there's a diagnosis of adjustment disorder, and you gave the reasons behind that. Does a diagnosis of that in and of itself indicate that someone's not capable of parenting their children?
That diagnosis without treatment, even without treatment, typically does not render a parent unfit to parent their children. That adjustment disorder is one of the more common disorders, and with treatment, reaching out, using good coping, a parent can continue to care for their children as long as the stressor isn't emerging from the children themselves. Sometimes a child can have a serious illness that can cause adjustment disorder or trigger adjustment disorder, but here's not the case. It was apart from her relationship with her children.
And I was going to ask you about that. In your interviews with Ms. Louvier, as well as your review of documents in this case, did you find any indication that her issues with regard to adjustment arose from her children?
No, the records I reviewed and my evaluation of her did not reveal any specific issues for her regarding her children.
Did she have such issues with her ex-husband?
My understanding was that the divorce process and his antagonistic behavior, as she described it, was very difficult for her. Being separated from her children also was difficult from her. That's the depression component. The anxiety component was more from the stress of going through the divorce and the interactions she had with her ex-husband.
Did you identify any other than the divorce and ex-husband and the absence of her children? Did you identify any other stressors that were affecting Ms. Louvier with regard to the adjustment disorder diagnosis?
To a minor degree, being a business owner and having to go through the recent pandemic. But again, that was to a minor degree compared to the other stressors she had.
Anything else?
No.
Okay. So as a part of what you reviewed, you also reviewed some inpatient treatment records for Ms. Louvier when she was in a therapeutic environment for a 30-day period, correct?
Correct.
And those records are rather extensive, correct?
Correct.
Okay. And lots of intake notes, lots of opinions stated, lots of observations, some diagnoses as well, correct?
Correct.
And you took all of that into consideration in coming up with your conclusion, is that correct?
Yes, my evaluation was a snapshot of how she was doing during the evaluation time I spent with her. Historically, I did document the alcohol use disorder, but at August, September, that time period is a time period I was analyzing.
Right. So while you looked at those things, your analysis is a present one, not one that was made a year or two ago. Is that correct?
Correct.
Do things like that change?
Yes.
So kind of that was then, this is now type thing?
In terms of the diagnoses, the way I view it and the way we are to view it is that the evaluation is recording historical diagnoses and symptoms and then talking about what's happening now, or of course at the time of the evaluation.
Right. Now, do those prior records and prior diagnoses inform your opinion in this case?
Yes, and which I wrote alcohol use disorder because it was diagnosed before. And since it's in remission, I wanted to still represent it in the report as an important piece.
Okay. Now, I know you had multiple discussions with Ms. Louvier. With her particular situation, I think a lot will be made out of whether or not she gets on the witness stand and says the words, "I am an alcoholic." If she's not willing to say that, if she doesn't believe that she was an alcoholic, does that somehow make, with everything you know, does that make her an inappropriate caretaker for her children at this time?
Can you restate the question? I'm understanding the question to be if she does not claim she's an alcoholic, then
Right.
that means she is unfit for.
Exactly, because I think we all kind of have this impression that if you are an alcoholic and you don't admit that you're an alcoholic, then you're not dealing with your alcoholism. I mean, we've heard that, I think, over and over again. Is Ms. Louvier's diagnosis and what you've observed of her, such that she should be getting up and saying, I'm an alcoholic right now?
You raise a really good point. Stating that you're an alcoholic, that comes from the tradition of Alcoholics Anonymous, claiming that you're an alcoholic in order to move forward. Now, that's just one framework. That's just one way of viewing alcohol use disorder, but that doesn't mean it's the only way. We kind of have come to know, hi, my name is Dr. Pools, and I'm an alcoholic, that's the first step to recovery. That's just the first step to recovery in the Alcoholic Anonymous model. But, in terms of clinical psychology, remission of symptoms is what we are looking for. And that is a different kind of way of viewing alcoholism.
Okay. And so for your framework, what you're looking at is the remission of symptoms, as well as the other, basically just the emotional and mental state of the patient. Is that correct?
Correct.
All right. And is that generally accepted in modern psychology?
Yes.
Okay. I understand AA, Alcoholics Anonymous, is sort of its own thing, correct? It is a way of treating alcoholism. Is that correct?
Correct.
Is it the only way?
No, it is not.
Okay. And if someone is recognizing that they have a history of abusing alcohol in reaction to stressors, is that something that you would consider important in their ongoing mental health with regard to alcohol abuse disorder?
Yes.
And did Ms. Louvier indicate to you that she did have a history of abusing alcohol in response to stressors?
That and her psychiatric records both indicate that.
All right. So you have taken that into consideration in your opinion as well. Is that correct?
Yes. And according to the DSM, we're looking for specific symptoms. And in order to fall into remission or to no longer have that disorder, she's gotten there.
Right. And when you say the DSM, and I'm pretty sure the court knows, and I know counsel does, but Diagnostic Statistical Manual, and that's basically the guidebook for diagnosing mental illness. Is that correct?
Correct.
And it's kind of a laundry list type of thing, right? There are a number of factors for each disorder that you check off when making that evaluation. Is that correct?
Yes.
All right. So we've talked about the alcohol and we've talked about the adjustment disorder. Did you review records with regard to an alleged suicide attempt or something of that sort by Ms. Louvier, where she was admitted to a local hospital here?
Yes.
And did you review those thoroughly?
Yes.
And did you discuss that with Ms. Louvier?
Yes.
Did she indicate to you that she had attempted to commit suicide on that occasion?
She told me about the incident and that it was perceived to be a suicide attempt, but she in fact reported that she was not ever trying to end her life.
In looking at someone through all of the testing that you did, could you pick up on whether or not that person displayed suicidal tendencies or suicidal ideations?
Yes, it's part of our standard evaluation procedures.
Okay, and so was that a big part of what you did?
Yes.
And did you determine that Ms. Louvier had any suicidal tendencies or suicidal ideations as of the time of your evaluation of her?
She did not.
Did you detect anything other than this admission that happened and the characterization as an attempted suicide, anything else in her medical records or any of the other things that you reviewed indicating prior suicidal attempts or ideations or tendencies?
No, none other that I found.
So were there any other, we'll talk about the negative type of things, if you want to call it that. And I know in your field, we wouldn't call kind of mental illness or mental defect a negative thing, but were there any other things that us lay people would look at as a negative thing about Ms. Louviere that you looked into with regard to her ability to parent her children?
No, nothing else emerged.
So I'm not asking you, to evaluate the relationship between Ms. Louviere and her children from both standpoints, but from Ms. Louviere's standpoint, based on what you saw, are her statements and feelings and attitudes toward her children appropriate or in line with being someone who can take care of their children well?
Yes.
Okay. And I know, maybe one of the things that's a far extreme would be, did they show signs of having Munchausen syndrome or something like that? But does her attachment level and all of that seem to be appropriate?
Considering what she has gone through with the separation from her children, her response seems appropriate. She seems like to have healthy attachments to her children, although I didn't evaluate her children or their relationship. But from what I gathered from her, it seemed healthy and appropriate.
And I know I'm just asking you about kind of a one-way street attachment level here. The kids may love her to death or hate her, but as far as her attachment to her children from her end of it, it's appropriate. Is that correct?
Correct.
She's not one of these needy parents whose entire existence is wrapped up in their children and everything ties to that. I'm sorry, Ms. Packard's right. I mean, Ms. Elvig is raising her.
I've let you lead. You're expert. I'm going to object to continually leading her. I know it saves time, but I need the record to reflect, Your Honor. I make objection as to leading.
I'll do better, Judge. So did you detect, I just summarizing, did you detect anything in her attachment to her children that was indicate that there's a problem with her being a caretaker of the children?
I did not observe anything like that.
And what is, in terms of Ms. Louviere's ability to take care of her children on an unsupervised basis, did you detect the need for any type of restriction on her in her caretaking of the children?
In my evaluation of her, I didn't detect anything regarding her mental health status or her history of substance abuse at the time of the evaluation to impair her ability to take care of her children.
Pass witness.
Ms. Elvig?
Thank you. Okay, I want to go back, Ms. Peugeot, and be sure I'm on the same page with you. The records that you reviewed that were provided to me include, and let's go through that, they are P7 with our court reporter. It appears to be a picture of a card, Linda Sinsat, MSLPC. These records are dated June 7th, 2018, and consist of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 20 pages. Is that part of what you reviewed?
Yes.
Okay, we're trying to do this Zoom, so I'm going to walk through. Then the mission statement that you reviewed from Taylor Recovery has pages 1 through 10 that appears to be an admission assessment. Then a discharge plan, page 1 of 2, a discharge summary, page 1 of 5, a master treatment plan, that is page 1 of 9, an admission history and physical form, which consists of page 1 through 5, And then some pages from Best Notes printed that looks like the medication she was on at that time, which consists of 1 through 3, a psych evaluation consisting of page 1 through 3, a psychological assessment, which is pages 1 through 6, a treatment plan review, and this one is missing a page. So there is, it says page 1 of 6, then 2 of 6, which appears to be a different document. I'm not sure unless that's part of the treatment plan. And then there are 6 pages of that. Is that what you have before you with Taylor Recovery Center?
That seems about right, yes.
Okay, well, my concern is you also said that you did you were reading some observations. I've not seen any observations. So I just want to be sure I have the same records you have.
What observations?
Well, I don't know. Let me get this last bit, and then Memorial Hermann clinical note, which starts with page 4 of 5, 5 of 5, behavioral health note, which consists of 1 of 5, 2 of 5, is missing 4 and 5, behavioral health note, 1 of 1, emergency department assessment, 1 of 1, emergency department triage, that's missing page 1. It has page 2, 3, 4, 5 of 9 pages. Are those the records that you reviewed in preparation of your report?
I forwarded all that I received, so I did not look at the page numbers specifically, so I wouldn't be able to answer that. I did forward to the court everything that I received.
Okay, and so in general, because they were provided to me by Mr. Falco, so that is what you've got, that you reviewed to conclude your assessment.
Yes.
Okay, that documents with our court reporter previously marked petitioner 7 asked that it be admitted.
I have no objection, Judge.
Okay, so petitioner 7 is admitted.
Now, in your front, on your cover page of your psychological summary, you said that you went over the court timeline as well. What court timeline did you review?
Through the district clerk's publicly available case timelines, I did a search for the case and just reviewed the dates, the entry dates.
Okay, and I would refer to that as the case summary. And that was forwarded to you, I believe, by Mr. Falco as petitioners 2. Is that what you reviewed?
The PDF that was forwarded to me was actually blank. I believe there was a mistake in how it was scanned in.
Okay.
Right, that was, if I may for the court clarify, Dr. Pujols notified me of that just shortly before I got here today. And I got with the court coordinator and she rescanned it because it was in fact blank, the one that we received.
Okay.
And we re-forwarded it to Dr. Pujols, but she'd only have gotten it about 15 minutes before we started this testimony. So that's what the issue is with that.
Well, Dr. Peugeot, would you look at that email and confirm that this is what you pulled up from the district clerk's office?
Yes.
And so P2 is your court timeline that you reviewed.
Yes, I see it now.
Okay. I just want to be sure I'm on the same page because I have questions about that. Okay. Well, in going through your records reviewed, which are draft 7, okay, did you attempt to get any records outside of what was provided to you by Farrah Levere?
The additional records that she provided to me were the drug tests, but apart from that, I didn't request any records directly from other facilities.
Okay. And you are making the conclusion or the opinion that she continues to meet the criteria for adjustment disorder and that she's in early remission of alcohol use disorder. But are you, when you look at the timeline by the court, did you review or pull any of those documents?
I only looked at the case summary. I don't think I have access to pull different reports.
Were you aware that she is the one who filed, if you just look at this case summary, I want to go through it with you.
Okay.
That Mrs. LeVere filed the original petition and did an affidavit to get a protective order that was issued that she kept Mr. LeVere from having Christmas with the children. Did you pull those documents?
I only see the entry date and the application for a protective order.
Were you aware that Mrs. LeVere kept the children, I mean, with no phone, no contact through the holidays until, if you look on page 3, there was a hearing in January in order to allow Mr. LeVere to have any visits with the children?
I do believe we talked briefly about the protective order, but that situation was apart from, it was informational, but not the goal of my evaluation of her mental health status.
Okay. Would you have concerns if she were not truthful to the court in the affidavit? Because she alleged that Mr. LeVere was a raging alcoholic. The children were afraid of him. They couldn't be near him. If you had pulled the affidavit, you could see her allegations. I mean, she's the one who filed. She's the one who's attempted with great animosity to keep the children from their father.
Object to form question. Counsel's characterization of animosity.
If that's what,
Objections overruled.
if that is what is in that affidavit, because this court's reviewed it, would you want to know that, and would that be taken into consideration of your opinion today?
Well, from just your description, it sounds like she was trying to protect her children, which in contentious custody cases, this kind of reaction does happen. So I don't think it's outside of what we would see in such a case. And again, I can't make any determination on Mr. Louvier's drinking other than that Ms. Louvier referred to them as, they would drink together. And that's the extent of what I can speak to.
Sure. And so the majority of the information gathered, with the exception of a few records, is based on what Mrs. LeVere tells you. Is that correct?
Yes.
Okay. And then looking at the case summary, did she also, if you go look at on June 24th, 2019, there was a motion for additional temporary orders. Did she tell you that in June of 2019, she had refiled with the court again to limit Mr. LeVere's time with the children?
Let me review because I did provide a summary, but I have additional notes on what she told me.
Okay.
Okay. I just note that she did request the protective order, and then he was granted standard possession and then filed for extended standard in early 2019. And that's the extent of the information I have there. I didn't catalog the goings on of the court case in court, just the date of the initial filing, and just to corroborate some of the dates that she was telling me. So this was less about the custody, the custody exchanges in whole, and more about her mental health.
Okay. Again, relying on solely what she reports to you, correct?
Of course, and this is the issue, one of the limitations of an individual psychological assessment. A custody assessment, as Mr. Falco mentioned, covers everyone, all parties, children involved, and I'm here solely to evaluate Ms. Louvier and her parenting fitness. I can't really speak too much about what she said or what she filed during the course of the case.
Again, I'm going to walk through this because I want to be sure that she was truthful with you throughout this process. Because if Mrs. Louvier is not truthful with you, then that would alter or impact your opinion, would it not?
Yes, and specifically to that, we do have, I guess in a way, a truthfulness or impression management scale in one of our objective measures. And it did not reveal that she was being defensive or trying to hide information. So that's one of our little, I guess, keys that we have to kind of confirm or to see if a person is really trying to put their best face forward or to skirt around some of their negative attributes. And I didn't find that with her.
And you would agree with me that people are quite capable of doing that.
Yes, the MMPI is designed to pick up on people who do that.
Would you look at July on page 7? We're back in court for July the 1st, 2019. Again, it's Farrell Louvier's motion for additional temporary orders. You did not review that.
No.
Okay. If you keep going forward, were you aware, I would think you would, that there at the beginning in August 16, 2019, there was a hearing, and then shortly after that, we've got interlock devices. Were you aware of did she share with you the allegations of alcohol? Again, she's alleging that Mr. Louvier is a raging alcoholic and is not safe with the children. And then the court ordered interlock devices for both parties. Do your notes reflect her telling you anything about that?
I do know that she had an interlock device. We did not speak about what Mr. Louvier had.
Okay. Did she share with you that she, even with the interlock device, had tested positive for alcohol and it was removed after Mr. Louvier's?
I don't believe we talked about that.
Would that have any impact on the opinion you're giving today?
That would match with her symptom history. If she tested positive at that time, it would correspond with what I observed in my evaluation.
Did she tell you, going to page 10 in March, actually on March 16, 2020, that the court, after a hearing, literally flipped the residency of the children because during spring break, when she had the kids, they were wanting to see their daddy and hollering in the car and whatever, and she was having trouble handling those kids. She drives them back to dad's. She's been drinking. She's run off the road. This is right in the beginning of COVID. And the law enforcement wouldn't let her drive home. Did she tell you about that incident?
I don't believe so, but that fits with the timeline of the alcohol use disorder that she and I spoke of.
Would the fact that she had that incident, let me ask you it this way, would you agree with me that with her symptoms, that could repeat itself?
If a person were to resume drinking at the same level as they were previous when they were diagnosed with the disorder, then patterns like that are likely to repeat.
Okay.
So
Now,
anything in 2019, in 2020, that those behaviors would fall under alcohol use disorder. So her remission began in this year, 2021. So behaviors in the past, yes, they match the disorder, but
Okay.
since remission, it's different.
When did she tell you that she went into remission?
I have it in the report.
No, I just saw that you have her listed as in full remission. Alcohol.
In early remission.
Early remission. When did she tell you that she quit drinking?
Starting or end of June, starting July 2021.
Okay, so that's July, we're in October. So July, August, September, 3.5 months. Is that not unusual if someone wants to quit drinking and then they would have a relapse?
I can't speak to the rates of relapse because every case is different, but relapse or slipping, taking one drink, is a possibility with anyone in early recovery.
Well, and I want to walk through this. She also going back to the court timeline. I want to go back and look at, okay, so we covered the March 20 event. So that spring break, there's evidence that this court has of her drinking and driving with the children. Then if you look forward, at that time in March of 20, we again start interlocks on Mrs. LeVere. If you go to page 11, you can see those, the filed interlock reports. And at that point in time, she is no overnights with the children, and she has various people bringing her the children. And she has to go into an interlock before they're left, not necessarily supervised for safety purposes. So did she talk about that with you at all?
Not in specific detail. We didn't talk about every moment or every result or outcome of the court hearings that she went to.
Now in June, let me go back to the next page. We entered temporary orders in July. You go to page 13. We've got drug testing, and I will. Did she share with you that she had tested positive for cocaine at one time?
I don't recall. I'd have to reference my notes. In 2020, she reported use.
Okay.
Yes.
Did she report any other drugs to you that she was using that were non-prescription drugs?
Cannabis in 2017.
Okay. Now, in October of 2020, the court heard this matter and took it into consideration and issued the final decree. And at that time, the court made the ruling that the parties would have 1 week with the children, 1 week on, 1 week off. Okay. So they would be with dad for a week, and then there'd be exchange. They'd be with mom for a week, and then they'd go back and forth. Did you visit with her how that went?
No.
Okay. And this is important. And that's in January. Now in March, she has the incident where she denies that she was attempting suicide. However, okay. No, wait, I don't, so she needs to move her car? Oh, I do. I do. Okay, I'll go move my car. Okay, I think, well, here, I'm gonna give you the keys. Hold on, guys. I gotta go, here, would you go move my car somewhere? Okay, sorry, the bailiff came and got me. So, now we're in March, so we have a fight, the kids are back and forth between the parents. She's had limitations with the children because of her alcohol and drug use. So now we have 1 week off in less than 3 months, in March, she is found in her garage, her alcohol level, which is supported by the records at Herman Memorial, or is 0.332. She denies any mental health issues, drug use, or whatever. And yet her friend found her with the car running, carbon monoxide. Now she has a whole different spin on this, but it appears from the evidence that she appeared to commit suicide. So did you go over that with her?
Yes.
Okay, and I understand that Mrs. Levere has a different perception of what occurred or what it looked like to the rest of the world. But would you agree with me that she has issues in dealing with reality?
I could say at that time she had issues with alcohol consumption. Now, again, the behaviors that were observed and reported to the court prior to, I guess, July 2021, and after she started to begin sober, sometimes it takes individuals a while to get to the point where they, in the AA term, hit rock bottom and start to fully stop all consumption. Those behaviors prior to that time are going to be like these moments of using alcohol when it is not appropriate around the children, making allegations, having even to take tests, use an interlock device. So the history that you're describing is, yes, that's during alcohol use disorder time period, and that those symptoms are clearly representative of the condition.
Well, and would you agree with me, given the fact that her perception is different, her presentation of that is different than what actually happened, should be a concern for the court as to the best, at least as to the safety of the children?
Well, we only know what the intake individual at the hospital recorded. We only know her side. To really identify what happened in that garage, no one was there observing live. So I can't say what happened. I can't say who's right, who is not being truthful. All we have is the data that was collected.
Okay. And did you speak with Miss Marsh, her friend that she texted and said goodbye to, and is the person who actually found Mrs. Levere and saved her life?
No, I did not speak to that person, but I was made aware by Miss Louvier that that friend is also a friend of her ex-spouse, and she felt that there was some kind of friction between her and this individual. So again, that's a third version of the story.
Okay. Well, and again, you can only rely on what Mrs. Levere told you. Isn't that correct?
Yes.
Because
yes.
You never consulted with Miss Marsh. You didn't go look at any of the videos. You didn't pull the police report. So again, you can only rely on what Mrs. Levere's perception is that she told you.
The only objective piece of data that I was able to pull from all of that was the blood alcohol content, which matches a diagnosis of alcohol use disorder.
Okay, and that, if we look at the records for the Memorial Hermann clinical notes, and I believe I found it, it's like 0.332. That's significant, isn't it?
Yes, it's very high.
Okay, and would it not be a concern, because I understand the MPI or whatever the MPI, because that has to be really reviewed by another licensed psychologist. So I didn't ask for those records. So that is a little more objective. It's an objective test. But I also understand that you're taking into consideration these other records. And would you agree with me? The admissions assessment or the records from Taylor Recovery are significant, are they not?
Yes.
And the Memorial Hermann clinical records that we have, those are significant, are they not?
Yes.
Okay, and the fact that she has a tendency to not be truthful, either in those, in the records, especially the Hermann Memorial, have you taken that into consideration?
I did not find objective evidence that she was being untruthful.
Well, let's look at page 2 of the behavioral note in the Memorial Hermann clinical note. It's actually page 4, where she was asked by Elisa Perryman of her treatment history. And she basically denied that she had ever been in treatment or had a mental health condition or any of those. I consider that significant. Why would you not?
Was that while she was under the influence of alcohol?
Correct.
So I don't know if a person with a blood alcohol, let's say of 0.2 at that time of the intake, which should be taken for her word. You know, you have to kind of look at the situation. She was highly intoxicated. Okay, so I can see symptoms of the disorder there. Were her words exactly? I don't know if I would place much weight on those words while she's under the influence. I'm sure she was very embarrassed in that moment, and you know, a whole slew of emotions having to be there. So I hear what you're saying, but I don't know if I would perceive that as not being truthful. Maybe defensive, embarrassed, frustrated, not wanting to be there, still intoxicated. That's what I see.
Okay. And both on the Taylor, let me back up. Mr. Falco in his direct, and you agreed that Mrs. Levere spent 30 days at Taylor Recovery, but that's not correct, is it? She checked herself out early.
I read that she completed it. Let me see. And just to let you know, let the court know, I don't have too much time left. If that influences anything, but I'll do my best.
Dr. Peugeot, we're going to finish you before you go to the next thing. So I still have questions. So
Judge, I informed the court yesterday that Dr. Pujols had from 1 to 2 today, and from 2 to 4, at least as of yesterday.
From 4 to 5.
Sorry, 4 to 5. I'm sorry, from 4 to 5. So that's where we are right now.
Respecting that, Your Honor, I will try to wrap it up, but I'm entitled to cross-examine Dr. Peugeot on behalf of my client.
Right. We'll let you cross-examine. Now, whether or not we have to take a break in between cross-examinations is one thing, but let's go ahead and see what we can do.
So where in the admissions assessment, or actually not admissions, the Taylor Recovery Center, did you find in which she completed the program?
It's somewhere in the Taylor Recovery documents. I wrote, she successfully completed the program and was discharged to outpatient care and community-based support groups. And so it's in there.
Okay, and it was under the recommendations that the discharge plan, which is about midway through that, she was committed to staying sober, abstaining from all mind-altering substances, attend 12-step meetings daily for 90 days. Thereafter, as recommended by her sponsor, maintain daily contact with sponsor, work the steps with their sponsor. What was her excuse for not following the discharge summary to you?
I didn't ask her specifically why she didn't follow these things. I do know that she continued, or she did have her counseling. Oftentimes, and I work in an inpatient facility, oftentimes you give discharge notes or just discharge plans to patients, and we don't know if they follow through. There's no one checking on them, or, you know, it's on, the onus is on the patient to follow through on those things. So sometimes people decide, you know, my life is going in this direction. I don't have the money, resources, time to follow through on some of these recommendations. The intention is often there, but there's no one to be made accountable. What I do know is that she continued seeing her providers and going in to counseling when she could. And I think that makes for a good discharge plan.
Okay. And in fact, would you agree with me, the Memorial Hermann discharge plan or recommendations were similar, that she continue counseling, go to AA, follow through, because between the March, a year, she wasn't doing anything. She certainly wasn't sober. Hence the repeated incident in March of 21. Would you agree?
It appears that she relapsed after Taylor Recovery Center continuing to drink.
Okay. And while she's been, or at least informed you, that she has not been drinking since July, sitting here today, can you honestly and professionally assure this court that she's not going to relapse and put these children in danger?
I can assure the court by the hair follicle test she completed on September 2nd. That goes back 90 days and indicates that she has not consumed alcohol. Now, that is something that is an objective measure more than what I can tell the court about my observations. And I know she's willing to be subjected to repeated hair follicle tests to show that there is not a molecule of alcohol in her system. I think that's pretty good.
Okay. But you can't, in fact, even in your opinion, you state specifically on page 3, your opinion for psychological fitness for parenting role is that she appeared, past tense, to be psychologically fit for parenting her 2 children, and that she furthermore appeared, past tense, to be psychologically fit to participate in unsupervised visits with her 2 children. Is that correct?
Yes, at the time of that evaluation.
Okay, and in fairness, Dr. Peugeot, none of us, you're not sitting here telling the court that you don't believe that she would relapse or would not relapse, and that the children would be in danger if she is allowed unsupervised visits.
Can you repeat the question, please?
That's probably a bad question. Let me try again. Okay, in fairness, we've got a case of an individual, and I would agree with, in your direct with Mr. Falco, AA doesn't work for everybody, but mental health issues are just that. And apparently, Mrs. Levere is seeing a non-licensed spiritual therapist. Okay, so not a licensed therapist that can deal with mental health. Okay, and
state facts, not an evidence.
It's what she testified to yesterday. Okay, that she is seeing an Angela Hardy who's not licensed in the state of Texas as a psychologist. And she's free, and she makes a donation for her, and it's a spiritual basis, that she has been to AA, doesn't have a spot, doesn't like it. And that's what Mr. Falco was asking about, because would you not agree with me? In order to get healthy, you need to be admitting your unhealthiness so that you can look at those issues and work on them. Would you agree with me?
Yes.
Okay, and so we have an individual that says, I'm not drinking, who gets stressed or blames her ex-spouse for everything wrong in her life. And so in fairness, you can't sit here and tell this court if he allows unsupervised visits that she's not going to have a relapse, a fight with her ex-husband, and cave in to these stressors and start drinking, can you?
I can say that that is a possibility,
Okay.
that the stressors can be overwhelming and then unwanted behaviors can emerge, which oftentimes what I've seen in cases like this, that there is a progressive steps towards unsupervised visits where the individual can be monitored and attend the expensive professional counseling. I know Houston has some resources for individuals on a sliding scale for professional counseling. So not saying, yes, go have your children unsupervised like you had before, but understanding the pattern. It's like, okay, well, we'll start here. Hair follicle tests, supervised, then unsupervised for a longer period, and just to kind of slowly acclimate without overwhelming the parent. Now, that's something that I've seen that's worked very well. Of course, when there's substance use, history of those unwanted behaviors, and there's much concern for the children's safety, that a stepwise program like that might be helpful and allay the fears and concerns of everyone involved.
Okay. And you would agree with me that some type of recommendation should include alcohol and drug testing and some evidence or just proof that there is progress with a licensed professional helping her deal with the stressors, which so far we have a history of possibly putting the kids in danger that I don't think any of us want to buy into. Would you agree with me with that?
Yes.
Okay, because really, in fairness, you can't sit here and guarantee this court that if you just return the children to her without any restrictions, that she's not going to have a relapse, and we're back right into another car wreck with the children.
Looking at the history of patterns, we're in early remission right now. We want to take safe steps to reunification.
One other thing, did she tell you about when she totaled her vehicle in April of this year?
I'm not aware.
Okay, and would you not agree with me? It would be important to you to have all of this information before you with respect to an individual granted, the MPI is objective, but even as a forensic psychologist, you would want all of that information in rendering opinion, would you not?
Preferably, I would like all the information, but sometimes I don't know to ask every single thing under the sun. So I just take what I have, and I think there was a substantial amount of records provided to make the diagnoses.
Okay, and so would you agree with me, the court has heard this case since it's been on record here, and that he would be the judge or the credibility of the witnesses?
Can you repeat that again?
Well, would you not agree with me? You've only had Mrs. LaVere report to you, correct? You have not conferred with Mr. LaVere, Terry Marsh, or anyone outside of Mrs. LaVere to confirm whether or not she's telling you is the truth.
Correct.
Okay, so you don't have any way to weigh credibility in this case as to Mrs. LaVere?
With collateral interviews, no.
Okay, all right. And I think, hold on, that may be it for me. You got anything? Did you see in your notes with Mrs. Levere that her perception of her life, she takes no accountability for any of her actions? It's always someone else's fault?
No, there were definitely moments where she took on responsibility. She was well aware of the way she reacts when she's under a lot of stress. So I think that was an important piece to the adjustment disorder. She was fair in taking responsibility.
So you would agree with me, in order for her to reach better mental health, one needs to take responsibility, accountability for your actions.
Yes, and she's verbalized that to me. She's told me she's willing to do what she needs to do.
Okay. And part of those stressors are her relationship and co-parenting with her ex-husband, correct?
Yes.
The business owner, money, as far as her budget, that's a stressor, isn't it?
My understanding is that she has closed her business and now she has employment that is much more manageable. She doesn't have to take on the whole business on her own. She works for someone else.
Okay. Did she explain to you that she's still a business owner as an independent contractor? So those stressors may still be there?
I think, yes. So she's under independent contract, but there's a whole infrastructure where she works, handling phone and budget and scheduling and all that. So it's more of an employment style contract is what she explained to me.
Would you agree with me if that were to go south, if she not have as many independent contractor positions or not make enough money to maintain her lifestyle, that would be a stressor that she'd have to deal with?
Yes, and that would be a stressor for anyone to deal with.
For all of us. And again, could lead her into relapse.
It could, but we can't say for certain.
Correct. I mean, because I'm staying with you with this, because you're not here to tell the court or to make any guarantees to the court that she is able to have these children without this little stair-step program, because she's in early remission with her alcohol problems.
Yes.
Okay, I pass the witness, Your Honor.
All right, so I know Ms. Pujols has another commitment, so I guess we could either end it here, Mr. Falco, or, I know we still have some other witnesses. We could pick up with those other witnesses, and then if you want to come back at 4 o'clock and continue, which would you like to do, Mr. Falco?
Judge, if I can ask one question.
All right. Give you one, and just realize that Miss Elva gets another chance too. Go ahead.
And my question is, has anything that you heard here today, or any of the information that you've received here today, changed the opinion that was stated in your report?
No, it does not.
That's all the questions I have.
And I have no questions, Your Honor. Okay.
All right, so if that's the case, then Miss or Dr. Pujols will let you go. The witnesses are under the rules, so just don't discuss your testimony about what you talked about today with anybody until we're done.
Thank you, Your Honor.
Thank you. All right.
Thank you.
Okay. All right.
Do you want us to come back in there?
Yeah, let's take about a 10-minute break, and then we'll reassemble here in the courtroom.
Perfect. Thank you, Your
Judge,
Honor.
I was told you had another hearing that was coming in between us that was just a little short one or something. Is that correct?
See, do we have another hearing coming? They're outside. Oh, okay. I think that's just a little prove up, so I'll probably do that right now. So if you want to head on this way.
Okay, thanks.